significant order. The Delhi High Court has allowed a 28-week-old pregnant woman to terminate her pregnancy. This after substantial anomalies were found in the fetus. While allowing this termination, the Delhi High Court said, and I quote them here, that the reproduction is the choice and right of a woman, and she can't be deprived of the freedom to take a decision to continue or not to continue with the pregnancy in the backdrop of the fetal abnormalities, unquote. Now, this is a significant step because the Medical Termination of Pregnancy Act does not permit termination of pregnancy beyond 24 weeks, and the petitioner in fact, approached the court for the said termination, and the judgment was in favor of the petitioner.
A woman who was 28 weeks pregnant was allowed to go ahead with medical termination of her pregnancy because this is significant because the permissible period is of 20 weeks or 24 weeks of pregnancy when you're allowed to medically terminate your pregnancy. In this case, particularly, the court noted that there was a substantial fetal abnormality. The fetus of the woman basically was suffering from a rare congenital heart disease, and the court said that if this pregnancy were to continue, there was a serious risk of the woman suffering mental health issues as well. So in this situation, what the court said was that reproductive choice is a facet of reproductive rights of a woman, and that is a dimension of her personal liberty, which is enshrined under Article 21 of the Constitution, and therefore it is her choice to medically terminate this pregnancy.
Senior lawyer Abha Singh now joins me on the phone line for more inputs on the story. In fact, Ms. Singh, this is a very, very important judgment there by the court, and the focus now is back at the reproductive rights of women.
I think the court has taken a very right stand that reproductive rights are a part of Article 21, that is right to life, and a woman's right to life is prime. In fact, as I was hearing that earlier, you could abort a 20-week fetus, then it was increased to 24, and now in this case, a 28-week fetus has been allowed to abort because it was threatening the life of a woman. I think not only in such cases, but also in cases where women have conceived because of rape, gang rape, they should also be allowed to abort at any stage, because it should be a right of a woman to decide whether she wants to have that child which is besetted due to rape. So I think today by court saying that the crux is not aborting a fetus, but the crux is that reproductive rights are the rights of right to life under Article 21, and a woman should have a say in that is the crux.
Also, Ms. Singh, this also raises some serious questions on the existing abortion laws in the country, and all of that is being ridiculed by the court with this particular judgment.
Absolutely, it is the patriarchal mindset which had that after 20 weeks it will not be aborted because it is the right to life, and our laws are old, archaic, and today with so much of medical facilities and so much of women's rights, let it be decided by the women concerned. Of course, the court has now said that in all cases there is a medical board of government doctors who see whether case by case they decide. But I feel rather than coming to a court for abortion, why should not the woman decide to abort if she wants to abort after the decision of a medical board? So in fact, I feel when courts have come down heavily, the next step should be that why should even for such matters be brought to the court? It should be between the mother, the woman concerned, and the medical board.
Absolutely. Thank you so much, Ms. Singh, for joining us with all those inputs.